Now before we begin this video, we should give a quick recap to those of you who may or may not have actually paid attention in the last one. Sampling, once legal, is now forbidden. Also, the court claims that it doesn't limit creativity significantly. To make sure that I fully understood sampling, I decided to do an interview with one of the associate professors at Drexel with an extensive list of accomplishments as a musician and producer. His name is Jim Klein, and he made some really good points about why sampling is and should remain illegal apart from a license. I'm going to do my best to counter his arguments. Warning, this video may get a little emotional. My name is Stevie Paris, and I'm going to talk about the ethics of sampling. Professor Klein said in response to one of my questions regarding the ruling, "As someone who makes and has made a lot of my income from royalties derived from sales and performance of music I've written and recorded, I can tell you that regulation is there to protect people like me." So, sampling is illegal without a license, which is reasonable when you're dealing with only one song. But this makes projects by artists like Public Enemy that took hundreds and hundreds of samples essentially impossible. It seems to me that with the advent of this ruling, an entire genre of music is condemned to death. I understand that those artists should be protected. I just don't believe that it's always necessary for licenses to be involved. Giving artists, or even often record labels, complete control over the entirety of songs produced is very close to the concept of a monopoly, and it concerns me. What right does an artist have to claim that those combinations of 4 notes belong to them in a particular sound? Does an artist have the right to claim copyright over an E note? Of course not. That would be ridiculous. So why does the law consider a series of notes recorded in a certain way illegal? I don't think there's really a good explanation to that question. I asked Professor Klein whether or not samplers can afford the price that artists would require of them, and in response he suggested, well, struggling artists can create their own tracks from scratch, just like those original artists did. Or they can find cheaper tracks from more obscure artists. Or they can recreate similar tracks, just like Dr. Dre does, to avoid the whole licensing hassle. I think this last part is an interesting point, as replays are indeed legal because they're considered covers. However, with the advent of MIDI sequencers, it's becoming harder and harder to tell the difference between the original lines and recreations. How long will it be before replaying is also illegal? If I replay your piece nearly exactly with a MIDI that sounds the same, will I be sued? I can't really be sure as to the answer of that question. The law surrounding sampling is too frequently decided on a case-by-case basis for anyone to really be sure about anything. Therefore, it has become the mentality of most artists to avoid any form of recreation like the devil, aside from explicit covers. The court, in its original ruling, said that licensing would not limit creativity significantly. I think it does. I don't see how it couldn't. But here's the thing. None of us can go off and sample because the law says, quite explicitly, that it's illegal apart from a license, which I know very few of us can afford. So, what are the legal arguments in favor of sampling? We'll get to that next time. This is Stevie, signing off.